Chapter 13. Pleas in Abatement. Article 1. Pleas in abatement generally considered. 240. Pleas in abatement defined. A plea in abatement. In our practice, either one alleges some matter, not otherwise appearing in the record, which, if true, will abate the suit, or 2 denies some matter, appearing in the record, which, if false, will abate the suit. If the plea is successful, the court is ousted of jurisdiction to proceed any further in the suit, and is, therefore, bound to dismiss the bill. If a fact, which if not alleged would be a ground for a plea in abatement, be alleged in the bill, it will be a ground of demurrer. There are only 2 pleadings by which the jurisdiction of the court can be disputed: 1. Pleas in abatement, and 2. Demurrers. A plea in abatement disputes the jurisdiction 1 by denying some jurisdictional allegation in the record, or 2 by alleging some fact not in the record. A demurrer disputes the jurisdiction by taking advantage of some 1 or more material allegations set out in the bill. But, inasmuch as a demurrer politely admits the bill to be true, pro hac vice, and disputes the jurisdiction by argument only, while a plea in abatement peremptorily disputes the jurisdiction of the court to try the suit on the merits, the court requires a plea in abatement to be filed before a demurrer. 241. Pleas in abatement and in bar, distinguished according to Tennessee practice. All pleas in our chancery courts are divided by our statutes into, first, pleas in abatement, and 2d, pleas in bar. All pleas that dispute the jurisdiction of the court to try the case, and seek to have the bill dismissed without any investigation of the merits of the controversy, are pleas in abatement. All other pleas are pleas in bar. The defenses that can be set up in a plea in bar may, also, be set up in an answer, and are generally so set NP, but matters proper for a plea in abatement cannot be set up in an answer. 242. Rationale of the practice in pleas in abatement. Good reason suggests that if a defendant desires to dispute the jurisdiction of the court, he should do this before he makes any defense against the merits of the case stated in the bill. For one, it would be a great waste of time and of money to contest a case on the merits, by putting in an answer, and taking the depositions of witnesses and other proof, and going through the forms of a hearing, if the party did not intend to submit to the decision of the court when made, and 2. It would be mere trifling with the court and the opposite party, if not an act of bad faith, to make such a contest when the defendant reserved the right to dispute the jurisdiction of the court in case the decision, or the probabilities, were against him. The uniform rule of all courts has, therefore, required a defendant who intended to dispute the jurisdiction of the court to do so at the outset, and before he made any defense to the charges against him on the merits of the controversy. For, if he could show that the court had no right to try him on the ease made by the complainant, then good reason and good faith required him to show it in the very beginning, in limine as the books say, and thus save time, trouble, and expense, and preserve good faith to the court. 243. Pleas in abatement, how divided in our practice. Pleas in abatement, in our practice, may be divided into 1 pleas in abatement to the process, and 2 pleas in abatement to the bill. 1. Pleas in abatement to the process attack the process by showing 1 that it wrongfully issued, or 2 was wrongfully executed. 2. Pleas in abatement to the bill attack the bill by showing 1 that the court has no jurisdiction of the person of the defendant, or 2 no jurisdiction of the subject matter of the suit, or 3 that the bill is prematurely filed, or 4 that the complainants are not partners as they allege, or 5 that by reason of some other matter the bill should be abated. Article 2. Pleas in abatement to the process. 244. Pleas in abatement to the process generally considered. Pleas in abatement to the process are unknown to general equity pleading, all such pleas being to the bill. But our chancery system of pleas is largely statutory, and our pleas in abatement in the chancery court are analogous to such pleas in the circuit court. Pleas in abatement to the process may, in order to avoid confusion, be divided into 1. Pleas in abatement to the subpoena, and 2. Pleas in abatement to the attachment, and will be considered separately. 245. Pleas in abatement to the subpoena. Pleas in abatement to the subpoena are those that seek to terminate or abate the suit by reason of some fatal irregularity in the issuance or service of the subpoena. They include the following. 1. That the process whereby the defendant was brought before the court was issued or served on Sunday in a case wherein such issuance or service is not authorized by law. 2. That the process was served on the defendant while attending his duty at a muster of militia or at an election, or as a witness or juror. 3. That the defendant is a joint drawer of negotiable paper with others, and the original writ was not served upon any one of the joint drawers. Plea to the subpoena. James Martin, V.S. Richard Ramsey, in the Chancery Court at Smithville. The defendant, Richard Ramsey, for plea in abatement to the suit brought against him in this cause, says that the subpoena to answer in the cause was executed on him by the Sheriff of DeKalb County, while he, the defendant, was in attendance at the Circuit Court of said DeKalb County, sitting at Smithville, the defendant being then and there in attendance as aforesaid, under summons as a witness in a suit pending in said Circuit Court between John Martin, plaintiff, and R. Stevens, defendant. And this the defendant is ready to verify. Therefore, he prays the judgment of the court, whether he shall be compelled to make any other answer to the bill, and prays to be dismissed. Richard Ramsey, State of Tennessee, County of DeKalb. Richard Ramsey makes oath that the above plea is true in substance and in fact. Richard Ramsey, sworn to and subscribed before me, Sept. 10/1/846. Charles Smith, C. and M. 246. Pleas in abatement to the attachment. The object of an original attachment of property is to compel the appearance of the defendant, and if the attachment is fatally defective, either 1 for want of a legal ground, or 2 for want of the prerequisites, or 3 because not levied on the defendant's property, the defendant may plead such facts in abatement to the writ. For when a complainant undertakes to obtain a decree against a man without serving a direct notice upon him, he should be required to take every preliminary step prescribed by the law as a substitute for such direct notice. The following are the grounds of a plea in abatement to the attachment. 4. That the grounds on which the original attachment writ issued were false or did not exist. 5. That the attachment was issued without affidavit and bond. 6. That the property on which the attachment was levied did not belong to the defendant. Article 3. Pleas in abatement to the bill. 247. Pleas in abatement to the bill generally considered. The object of these pleas is to defeat the jurisdiction of the court, 1. By denying some jurisdictional allegation of the bill, or 2. By alleging some matter not stated in the bill, which, if true, will defeat the jurisdiction. The principal pleas in abatement to the bill, under our system of chancery pleading, are the following. 248. Pleas in abatement because of the prematurity of the suit. If a suit is brought before the cause of action is matured, the defendant may plead such prematurity in bar of the action, or may set up the defense in his answer. But if the suit is brought before the defendant is liable to suit, by reason of some statute exempting him from suit for a season, he may plead that fact in abatement of the suit. Thus, if an executor or administrator is sued within 6 months after his qualification, unless the suit be by a surety of the deceased, the defendant is required by the statute to plead the prematurity of the suit in abatement. Plea in abatement because of prematurity of suit. John Doe, V.S. in the Chancery Court at Loudon. John Smith, Admer, and C. The defendant, John Smith, administrator of Richard Smith, deceased, for plea in abatement to the bill in this cause, says that he was appointed and qualified as such administrator by the County Court of Loudon County on the first Monday in January, 1891, and within 6 months before this suit was brought. Wherefore, he prays that this suit may be abated and dismissed. John Smith, Admer, and C. To be sworn to, as shown Roman 3 254, post 249. Pleas in abatement to the general jurisdiction of the court over the subject matter. The jurisdiction of the Chancery Court over money demands, where the suit is not in aid of a judgment creditor, is limited to debts or demands of not less value than $50. If, therefore, it appears on the face of the bill that the debt or demand is of less value than $50, the defendant may have the bill dismissed on motion or demurrer, unless the suit is in aid of a judgment creditor or to recover land or specific personal property. If the debt or demand be alleged to exceed $50, when it is in fact of less value than $50, the defendant may plead that fact in abatement of the bill. The defendant may, also, plead in abatement any other fact that will show the subject matter of the suit to be without the general jurisdiction of the court. Plea in abatement to the general jurisdiction of the court. The defendant, John Smith, for plea in abatement to the bill, says that the amount he owes the complainant in this cause is less than $50, and, therefore, beneath the dignity of this court, and he prays the judgment of the court, whether he shall answer further. To be properly sworn to. See Post 254. John Smith. 250. Pleas in abatement to the local jurisdiction of the court over the subject matter. There are various provisions of the statutes requiring that suits relating to certain specified matters shall be brought in certain specified counties, and if a bill dealing with these specified matters is filed in a county other than that specified in the statute, the defendants, even though personally served with process, may file a plea in abatement to the local jurisdiction of the court over the subject matter of the suit. The various requirements of the statutes as to the local jurisdiction of the court over the subject matter of the suit have already been fully stated and need not be repeated. In a general way, these statutes may be summarized as follows. 1. All bills to recover or to divest or clear the title to land, or to foreclose mortgages or trust deeds relating to land, or to specifically execute contracts relating to land, or to sell the lands of decedents to pay debts, must be filed in the county where the land, or material part of it, is situated. 2. All bills to foreclose mortgages or trust deeds on personalty must be filed in the county where such mortgage is registered. 3. All bills to sell the lands of persons under disability, or to partition, or sell for partition, lands held in common, must be filed in the county where the land, or some part of it, lies, or where the defendant resides. 4. All bills to transfer the administration of an insolvent estate from the county court must be filed in the county wherein the will was proved, or letters of administration were granted, or where the personal representatives reside or are served with process. 5. All bills for the appointment of administrators must be filed in the county where the deceased resided at the time of his death, or where his estate, goods and chattels, or effects, were at the time of his death. 6. All bills against cities and counties must be filed, 1 in case of cities, in the county containing the city, and 2 in case of counties, in the county sued if suits in reference to any of these matters are not brought in the county required by the statute. The defendant may plead that fact in abatement of the suit. The following is the form of a plea in abatement to the local jurisdiction of the court over the subject matter. Plea in abatement to the local jurisdiction of the subject matter. John Doe vs. John Smith, in the Chancery Court at Knoxville. The defendant, John Smith, for plea in abatement to the bill, says that the tract of land sought to be recovered in this cause, or the title to which is sought to be divested or cleared up in this cause, or the contract as to which is sought to be specifically executed in this cause, lies in the county of Anderson, and no part of it lies in the county of Knox. Wherefore, this defendant says that this court ought not to take further jurisdiction of this cause. To be sworn to, as shown in 254, Post, John Smith. 251. Pleas in abatement to the local jurisdiction of the court over the person of the defendant. While the Court of Chancery acts ordinarily in personam, and, therefore, suits may generally be instituted in any county where the defendant, or any material defendant, may be found, Nevertheless, there are some important statutory exceptions to this rule, and if any one of these exceptions is violated, the defendants may show the fact by plea in abatement and thus defeat the suit. The exceptions have been already set forth with particularity in considering the local jurisdiction of the court, and need not be repeated here in detail. The following are the principal grounds for pleas in abatement to the local jurisdiction of the court over the person of the defendant. 1. That the complainant and the defendant resided, at the time the suit was brought, in the same county, and the bill is filed in another county, and the court, where the suit is brought, has no local jurisdiction over the subject matter of the suit. 2. That neither the defendant pleading in abatement nor any other material defendant was served with process in the county wherein the suit was brought, nor do they reside in such county, and the jurisdiction of the subject matter of the suit is not in such county. The county in which a bill must be filed has already been fully shown. The following will serve as a guide in drawing pleas under this section. Plea in abatement to the local jurisdiction over the defendant. John Doe vs. John Smith. In the Chancery Court at Knoxville, the defendant, John Smith, for plea in abatement to the bill, says, "This suit is brought to recover an alleged debt, and the complainant and the defendant both resided in Anderson County when the bill was filed, and the defendant was not then, and is not now, residing in Knox County. Wherefore, he prays the judgment of the court whether he shall answer further. To be sworn to, as shown in 254, post, John Smith. 252. Pleas in abatement to the person under the old practice. Under the old equity practice, pleas to the person were in abatement. These pleas ineluded. 1. Pleas to the person of the complainant, that he is an infant, idiot, or lunatic, or a bankrupt, or that she is a married woman, or that the complainant is not the person he claims to be, or does not sustain the character in which he sues, and 2. Pleas to the person of the defendant, that he does not possess the character in which he is sued, as for instance that the defendant is not an unmarried woman, or is not an executor, administrator, guardian, or heir, or that he is a bankrupt. Under the Tennessee practice, all of these defenses can be set up in the answer, as they do not dispute the jurisdiction of the court, and are, therefore, not matters for a plea in abatement. But the legislature having enacted that, whenever 2 or more persons sue as partners upon an account, bill of exchange, bond, or note, it shall not be necessary for them to prove their partnership, unless the defendant files a plea in abatement denying the partnership on oath. Of course, such a plea by this ipse dixit becomes a plea in abatement, and due courtesy to a coordinate department of the state requires that it shall wear that cognomen. The following is a form of plea denying complainants are partners. John Doe and Henry Doe, partners under the name of Doe and Bro. vs. Richard Rowe, in Chancery at Huntsville. The defendant, Richard Rowe, for plea in abatement to the bill, says that the complainants are not partners as by them alleged in their bill. Richard Rowe. To be sworn to. See Post 254. Article 4. Frame and form of pleas in abatement. 253. Requisites of a plea in abatement under general equity practice. A plea in abatement must possess all of the requisites of a plea in bar, stated in subsequent sections, except 1. The ground of a plea in abatement must be sufficient to merely dismiss the suit, and not to bar it. 2. A plea in abatement must not touch upon any matters affecting the merits of the controversy. The requisites of an affirmative plea in abatement under the general equity practice are 1. It must be based on matter outside of the bill. 2. Such matter must reduce the decision of the cause to a single point, on which issue can be taken. 3. This point must be one that, if decided for the defendant, will dismiss the bill and not bar it. 4. The plea must be direct and positive, and not argumentative or inferential. 5. It must be verified by the direct and positive oath of the defendant, unless it is proved by a court record, and then it is verified by the record. and 6. It must be filed and determined before any other mode of defense is resorted to. A negative plea in abatement merely denies the jurisdictional allegations of the bill. If, after a plea in abatement has been filed, and while it is pending, any other defense is made, such as a demurrer, motion to dismiss, plea in bar, or answer, the plea in abatement will be deemed to be waived, and will be treated as abandoned under the general practice, but not in this state. Pleas in abatement are not favored by the courts, because they do not go to the merits of the case, and no latitude in practice is extended to them. They must always be filed in the right time, in the right form, and with the right verification. They are strictly construed and strictly dealt with, and intendments in their favor are not allowed to supply defects. A party who relies on a technicality to defeat an equity must not present an untechnical technicality, for a court of justice will not aid or favor him in his efforts to defeat justice. Nevertheless, the court will give him the full benefit of the law and will not violate its own rule of regarding substance rather than form. If, therefore, a plea in abatement is good in substance, the court will not overrule it merely because it is bad in form, but will allow the form to be amended. 254. Frame and form of pleas in abatement. An affirmative plea in abatement must contain a succinct statement of the facts relied on to abate the suit, and the forms given in the code, being models of brevity and certainty, can be safely followed in chancery pleading. A negative plea in abatement merely denies the jurisdictional allegations of the bill. The forms of the commencement and conclusion of pleas in abatement and in bar are substantially the same. John Doe vs. Richard Roe. Affirmative plea in abatement. In Chancery at Sevierville, the defendant, Richard Roe, for plea in abatement to the bill M said cause, says that he and the complainant both resided in the same county, to wit, in the county of Blount, when the bill in this case was filed, and that the said bill is filed in the county of Sevier. Wherefore, he prays to be dismissed with his costs. Richard Roe, State of Tennessee. County of Sevier. Richard Roe makes oath that his foregoing plea is true in substance and in fact. Richard Roe. Sworn to and subscribed before me. July 1, 1890. A. T. Marshall, C. and M. A negative plea in abatement merely denies the allegation, or allegations, in the bill on which the jurisdiction of the court over the person, or property of the defendant depends, as will be seen by the following form, and by other forms in this book. John Doe vs. Richard Roe. Negative plea in abatement. In Chancery at Sevierville, the defendant, Richard Roe, for plea in abatement to the bill in said cause, says that the tract of land sought to be recovered by the bill does not lie, nor does any part of it lie, in the county of Sevier. Richard Roe. To be signed and sworn to as above. The statute provides that no plea in abatement shall be received in any court, unless its truth is verified by the oath of the party, or otherwise, and if the proper verification is wanting, the plea may be struck out of the files on motion. Article 5. Pleas in abatement in attachment suits. 255. When a plea in abatement should be supported by an answer. When an attachment bill charges a fraudulent transfer of property, both as a ground of equitable relief and as a ground for an attachment of property, and alleges particulars of the fraud charged, a plea in abatement denying the alleged fraudulent transfer should be supported by answer denying the specifications of fraudulent conduct, when the defendant is called on to answer unto them on oath, because complainant is entitled to the discovery he seeks in aid of his charge of fraud. The bill in such a case combines 1. A pleading alleging indebtedness, 2. An affidavit of fraudulent transfer, and 3. A call upon the defendant for a discovery. But when an attachment bill charges a single fraudulent disposition of property, both as a ground of attachment and as a ground of equitable relief, without averring any matters of evidence in support of the charge of fraud, and the defendant by plea in abatement denies the fraudulent transfer, no answer in support of such plea is necessary. First, because there is no discovery to be made in the answer, and 2d, because all the answer could do would be to deny the fraudulent transfer, and that had already been done by the plea in abatement. Hence, an answer under these circumstances would overrule the plea under the old practice, but not under the present practice. A plea in abatement need not be supported by an answer when the defendant's oath to his answer is waived, for that is a waiver of any discovery. 256. Pleas in abatement in attachment suits generally considered. Proceedings in court by attachment of property are purely statutory. Attachments are of two kinds, original and ancillary. Hot, while both are obtained and executed in the same way, and both alike impound the defendant's estate, their objects are different. The primary object of the original writ is to aid in compelling the defendant to appear in court and defend the suit wherein the writ issued, and the secondary object is impound enough of his property to secure the debt sued for, while the only object of the ancillary writ is the seizure of the defendant's property as security for the complainant's demand, the defendant being brought into court by service of subpoena. All attachment suits, therefore, have a twofold object: 1, a decree for the debt of demand claimed, and 2, the seizure, at the beginning of the suit, of enough of the defendant's property to satisfy the decree when obtained. So, an attachment bill has a twofold nature. It is 1, a pleading setting forth a cause of action, and 2, an affidavit of some statutory ground or grounds for the preliminary seizure of the defendant's property to satisfy the anticipated recovery. As a result of this twofold attack upon him, the defendant has a twofold defense. He has a defense to make to the bill as a pleading, and another defense to the bill as an affidavit. His defense to the bill as a pleading is made by demurrer, plea in bar, or answer, and his defense to the bill as an affidavit is made by a plea in abatement, or, in some cases, by a motion to dismiss. 257. Objects of plea in abatement in attachment suits. The objects of the bill in all attachment suits are 1, to obtaining a decree for the demand sued on, and 2, to impound enough property to satisfy it, and in case of an original attachment suit, 3, to compel the appearance of the defendant. The object of a plea in abatement to the attachment, whether original or ancillary, is to abate the writ and discharge the levy made under it, thereby restoring the possession and title of the property to the defendant. And, in case of an original attachment, the abatement of the writ also abates the suit, for the suit being bottomed on the writ falls with the writ. And when the attachment is abated, and the levy thereunder discharged, any transfer of, or lien on, the attached property obstructed by the levy becomes operative, as though such levy had never been made. 258. Pleas in abatement not overruled by defenses on the merits. Pleas in abatement in attachment suits differ so materially from such pleas in ordinary equity pleading that considerable discrimination is necessary to avoid confusion and error. In ordinary equity pleading, the defendant is brought before the court by subpoena, served upon his person. But in an original attachment suit he is brought before the court by a seizure of his property, and notice of that fact, and of the suit, given him by publication. So, in an attachment suit the defendant may have two very different defenses, one to the merits of the suit, and another to the merits of the attachment, and may wish to set them both up by pleading in abatement to the attachment, and by demurring, pleading in bar, or answering, to the bill. But inasmuch as under the general rules of equity pleading, a demurrer, plea, or answer overrules a plea in abatement to the bill, it was once thought that they would, also, overrule a plea in abatement to the writ of attachment, whether such writ was original or ancillary, not considering the great difference between pleas in abatement to the bill in ordinary equity pleading and pleas in abatement to the attachment under our code pleading. It is, however, now settled, after much controversy and contrariety of decisions, that a defendant may, at the same time, plead in abatement to the attachment, whether original or ancillary, and demur, plead in bar, or answer to the bill, and that there is no inconsistency in the two simultaneous defenses. And the legislature has recently confirmed this adjudication by enacting that a defendant can plead in abatement, and plead or answer to the merits at the same time, and that his plea in bar or answer is no waiver of his plea am abatement. In case of either an original or an ancillary attachment, the defense to the attachment may fail, and the defense to the bill may succeed, or vice versa. The defendant is often benefited by defeating the attachment even when he fails to defeat the bill on the merits, because, when the attachment is defeated, the lien is discharged ab initio, and any intervening sale or lien becomes operative and valid. 259. Forms of pleas in abatement in attachment suits. There is no technical difficulty in drawing pleas in abatement in attachment suits. The attachment writ is grounded on the causes of attachment alleged in the bill, and the plea in abatement merely denies each and all of the causes alleged. Plea in abatement in attachment. John Doe vs. Richard Roe. In Chancery at Trenton. The defendant for plea in abatement to the writ of attachment in this cause says that he did not reside out of the state at the time the bill in this cause was filed, and has not since resided out of the state, and says that he had not removed himself or property, or any part thereof, out of the state when the bill in this cause was filed, nor has he since removed himself or property, or any part thereof, out of the state, and says that he had not fraudulently disposed of, nor was he about to fraudulently dispose of, his property or any part thereof, when the bill in this cause was filed, as said bill alleges. Wherefore, he prays that the attachment be abated, if it is an original attachment, and the bill dismissed. To be sworn to as in 254. Richard Roe. Plea in abatement to original and ancillary attachments. Mary Rawle vs. William Boone. In Chancery at Knoxville. The defendant, William Boone, for the plea in abatement to the original and ancillary writs of attachment in this cause says that he had not fraudulently disposed of his property or of any part thereof, nor was he about fraudulently to dispose of his property or any part thereof by the time of the issuance of such writs or either of them, or at any other time before or since that time, as in and by the bill of complaint is most falsely and erroneously alleged. To be sworn to as in 254. William Boone. Article 6. Proceedings upon a plea in abatement. 260. When a plea in abatement must be filed under general equity practice. Inasmuch as a plea in abatement undertakes to dispute the right of the court to take any step in the suit, the court requires the plea to be filed before any step is taken. If a defendant intends to dispute the jurisdiction of the court on any ground, common reason requires that he should do so at the threshold of the litigation, and the practice of the court accordingly is that he must file his plea in abatement before making any other sort of defense whatsoever. And not only must he file his plea in abatement before either moving to dismiss, or demurring, or pleading in bar, or answering, but he must have his plea finally disposed of before making any other sort of defense. For if, after filing a plea in abatement, he moves to dismiss, or demurs, or pleads in bar or answers, such a step is deemed an abandonment of his plea in abatement. D-lie will not be allowed to return to it. The court will not ordinarily allow a plea in abatement to be filed after a pro confesso has been set aside. The party who contests the right of the court to take jurisdiction because of some fatal irregularity in the issuance or service of process, or because of the locality of his residence or of the subject matter, must do no act that recognizes or acquiesces in that jurisdiction. He must dispute the jurisdiction, 1 in the right way, 2 at the right time, and 3 in the right form. 1 the right way is by a plea in abatement. 2 the right time is at the appearance term, and before any other defense is made, or any leave is asked or obtained in reference to any other defense. 3 the right form is a plea containing the requisite substance and a sufficient verification. But under the Act of 1897, a plea in abatement and a plea in bar, or an answer, may be filed at the same time, and the filing of a plea in bar or an answer will not overrule a plea in abatement. 261. When a plea in abatement may be filed and heard under the Tennessee practice, down to the passage of the Act of 1897, there was great contention at the bar, and no little difference of opinion on the bench. 1. As to when a plea in abatement might be filed. 2. As to the effect of filing a plea in liar or an answer on a plea in abatement. And 3. As to the effect of a decision against a plea in abatement upon an issue of fact. And these contentions between solicitors and differing opinions among chancellors were greatly increased and aggravated by the impossible endeavors to reconcile pleas in abatement in attachment cases with pleas in abatement in ordinary equity pleading, complicated as the former pleas were by pleas in abatement to the subpoena, a plea utterly unknown to equity pleading, and injected into our chancery pleading by the ill-considered act of the courts making the statutes in reference to grounds for pleas in abatement in the circuit courts applicable to the chancery courts. The Act of 1877 changes all this, and not only makes a plea in abatement equal in favor with a plea in bar or an answer, but in some respects makes it the most favored, thereby reversing all former rules of pleading. For the Act not only allows a plea in abatement to be filed along with an answer, thitherto the most favored of all pleadings by a defendant, but provides that if at the trial the plea in abatement is found true, the court is bound to sustain it and dismiss the bill, even though the answer fail to set up a good defense, or, setting up a good defense, is proved to be false and the bill proved to be true. The result being that a plea in abatement, if found to be true, overrules the answer. By the Act of 1897, the defendant may plead over to the merits of the bill after judgment against his plea in abatement rendered either upon motion to strike out, or upon argument as to its sufficiency, or upon demurrer, or upon an issue of fact as to its merits. In other words, no act of the defendant in unsuccessfully filing or relying upon a plea in abatement, and no adverse action of the court in reference to the sufficiency or truthfulness of such plea, will debar him from making any defense to the merits he could have made if no plea in abatement had ever been filed by him. But the statute goes further, and authorizes the defendant to plead in abatement, and, at the same time, to plead in bar to the merits or to answer to merits, and, in such plea in bar or answer, to rely on any defenses he might have made had no plea in abatement been interposed. The act of the defendant in filing a plea in bar, or an answer, after pleading in abatement, is not to be deemed a waiver of his plea in abatement, but both defenses shall stand, and the issues of fact raised by both shall be heard at the same time. And if the plea in abatement is found to be true, the suit will be abated and the bill dismissed, even though complainant may be entitled to a decree on the merits. But if, at the hearing, the plea in abatement is found to be false, the court will then adjudicate the case upon the merits in favor of the complainant or defendant as equity may require. Where a defendant unsuccessfully relies upon a plea in abatement, the issue of fact being found against him, and he fails to plead over, or apply for leave to plea over, a pro confesso can be entered against him, and then a final decree on the pro confesso. In case of either an original or an ancillary attachment, the defendant, without the aid of the statute, may plead in abatement to it, and at the same time answer the bill on the merits. 262. Setting a plea down for argument. The first question for the complainant to consider when a plea is filed, whether it be a plea in abatement or in bar, is its sufficiency. If he deem the plea insufficient, either in form or substance, he must set it down with the clerk to be argued. He may do this by an entry upon the minutes of the court, if in session, or upon the rule docket, or by filing with the clerk a paper containing the substance of such entry, if court be not in session. The following is a form of setting down a plea for argument. John Doe vs. Richard Roe. The complainant says the defendant's plea in abatement is insufficient. First, because it is not properly verified. 2d. Because, if true, it presents no ground for abating the suit. Wherefore he sets said plea down for argument. Edward T. Sanford, Solicitor. The plea must be set for argument at the first term after it is filed, and if on argument it is judged to be sufficient, the complainant must take issue upon it instanter. If, however, the plea is overruled, the defendant must answer the bill by the next rule day, which will be the next day if the term continues. B may, however, obtain further time from the court on application. 263. Taking issue upon a plea. Issue is taken upon a plea, whether it be a plea in abatement or in bar, by filing the statutory replication thereto, as follows. Replication of a plea. John Doe vs. Richard Roe. The complainant joins issue on the plea filed in this cause. Edward T. Sanford, Solicitor. This replication may be written immediately under the plea on the same paper, but whether so written or put in on a separate sheet of paper, it should be duly filed by the clerk. A negative plea makes an issue without a replication, and the practice is to treat an affirmative plea as at issue without a replication after complainant has had 20 days' notice of its filing and has taken no action thereon. If the complainant has ground for a special replication, he may file the same, in addition to his general replication, on obtaining leave of the court. A replication to a plea should be filed, or the plea set down for argument as to its sufficiency, before the lapse of 20 days after the filing of the plea. 264. Effect of the decision of a plea in abatement. If a plea in abatement is good, both in form and substance, the complainant must dismiss his bill, or take issue upon the plea, and have the issue tried upon the evidence. If, on the trial of this issue of fact, the plea be found true, the court will order the bill to be dismissed. Such dismissal, however, cannot be pleaded in bar of a second suit on the same cause of action. If the plea in abatement is overruled upon argument, the order of the court is that the defendant pay the statutory costs and answer the bill. The following is the form of an order ruling on a plea in abatement. John Doe vs. Richard Roe. No. 314. The plea in abatement filed by the defendant, having been set down by the complainant to be argued, and having been read, and argument as to its sufficiency having been heard, the court is of the opinion that the plea is sufficient. It is, therefore, ordered by the court that the complainant reply to said plea within 10 days if the plea be found insufficient. Omit add after the word opinion, and add, in lieu, that the plea is insufficient in law. It is, therefore, ordered by the court that said plea be overruled and disallowed, and that the defendant answer the bill within 2 days, and that he pay the statutory costs, for which an execution will issue. If the defendant wished to rely on his plea in abatement to the jurisdiction, in the Supreme Court, under the old practice, he had to decline to answer the bill and make no further defense, for any further defense was deemed an abandonment of his plea. But under the present practice, he has the right to defend on the merits after his plea has been found untrue on the facts. Where, however, the issue tendered by a plea in abatement is tried on its merits, upon an issue of fact, if the plea be found false, the complainant, prior to the Act of 1897, was entitled to an order taking his bill for confessed, and a final decree thereon. But now the defendant has the right to plead over to the merits, or answer. The entry on the minutes of the court, in case of a trial on an issue of fact, may be as follows. Decree on the hearing of a plea in abatement. John Doe vs. Richard Roe. No. 314. This cause came on to be heard this 18th day of April, 1891, before the Chancellor, or before the jury heretofore demanded in the cause, to wit, William Brown, and naming them all who were duly sworn well and truly to try and determine the issue made on the plea in abatement, and the proof having been read or heard, if tried by a jury and argument of counsel heard, the Chancellor or jury finds the issue in favor of the defendant. It is, therefore, decreed by the court that the bill be dismissed, and that complainant and frank friend, his prosecution surety, pay all the costs of the cause, for which let execution issue. If the issue be found in favor of the complainant, insert after the words, in favor of, in the above form, the following, the complainant, and the defendant not applying for leave to plead over or answer. It is, therefore, decreed by the court that the bill of complaint be taken for confessed, and, thereupon, this cause coming on to be further and finally heard upon the bill, the order pro confesso, and the whole record, upon consideration thereof. The court orders and decrees then give the decree complainant is entitled to, on a pro confesso. If the defendant has pleaded in abatement and answered at the same time, as he has the right to do under the Act of 1897, and the cause is heard at the same time upon the issues made by the bill and plea, and by the bill and answer, then this decree will be modified as follows. If the issue on the plea be found in favor of the complainant, insert after the words "in favor of" in the first paragraph of this decree the following: the complainant. And thereupon, this cause coming on to be further and finally, if it be a final decree, heard upon the bill and the answer of the defendant thereto, and the evidence and whole record in the cause and argument of counsel, the court is of opinion that complainant is entitled to the relief by him specially prayed in his bill. It is, therefore, decreed by the court that complainant have and recover of the defendant the sum of $7,654.32, $7,654.32, and all the costs of the cause, for which an execution will issue. If any property has been attached, omit all of the decree after the words "costs in the cause," and recite that property has been attached, and order its sale as shown in 887 post. If complainant has a lien upon any property, let the decree so recite and declare the lien, and then order the property to be sold as shown in 567 post. The Act of 1897 provides that a plea in abatement and an answer may be filed at the same time, and when so filed shall be heard at the same time, in which case the decree may be as follows. Decree on bill, plea in abatement, answer and proof. John Doe et al. V.S. in Chancery Court at Dandridge. Richard Roe. This cause coming on this day to be heard upon the bill, the plea in abatement and the answer, and the proof having been read as to all the issues and argument of counsel heard, the court finds the issue on the plea in abatement in favor of the defendant. It is, therefore, decreed that the bill be dismissed, and that complainant and frank friend, his prosecution surety, pay all the costs of the cause, for which an execution is awarded. If the issue on the plea in abatement is found against the defendant, then omit all in the above decree after the words "in favor of" and insert, in lieu the following: the complainant. And the court being of opinion that the complainant is entitled to the relief by him prayed, it is, therefore, ordered, adjudged, and decreed that for forms of decrees, see post 566, 568. 265. Effect of the trial of a plea in abatement in attachment suits. If the plea in abatement is to an original attachment, and the defendant is not before the court by service of subpoena, or by voluntary appearance outside of his pleadings, and the issue on the plea be found in his favor, the bill will be dismissed, as shown in the preceding decree. But if the defendant is before the court, and has answered as well as pleaded in abatement, if his plea be found in his favor, and the issues on bill and answer be found in favor of the complainant, then the attachment will be discharged, a decree rendered in complainant's favor on the bill and answer, and an execution awarded for the amount of the decree. In such case, in the preceding decree omit all after the words "in favor of the defendant," and insert, in lieu, the following: It is, therefore, decreed that the writ of attachment be quashed, and the levy thereunder released and discharged, and the costs incident to the attachment will be paid by the complainant. The court, also, finds the issues raised by the bill and answer in favor of the complainant, and it is, therefore, ordered, adjudged, and decreed that for forms of decrees, see post 566, 568, if the issues on the plea in abatement to the original attachment be found in favor of the complainant, and the issues on the bill and answer be, also, found in favor of the complainant, then omit all after the words "in favor of" in the foregoing decree, and insert, in lieu, the following: the complainant. It is, therefore, decreed by the court that the plea in abatement be overruled and disallowed. And the court, being of opinion that the complainant is entitled to the relief by him prayed, it is, therefore, ordered and decreed that here insert decree as prayed, and order the property attached to be sold, For forms, see Post 887. If the court on the hearing should decide against both the plea in abatement and the bill, then the bill will, of course, be dismissed, and the costs of the suit apportioned accordingly, adjudging the costs incident to the plea against the defendant, and the balance of the costs against the complainant, unless equity otherwise require.